that everybody can be aware, I do know Rebecca Martinez. She's never been to dinner at my house. I've never been to dinner at her house, but I do know her. We are colleagues. And when I see her, I say hello. She says hello to me. I may ask her about her day. She may ask me about my day. But I will tell you that my decision on this case is not going to be impacted by the fact that I know her. So if anyone has any objections to me hearing this, now is the time to say so. State?
No, Your Honor.
Defense?
Your Honor, I have all the confidence that it was fair and right in this case, so no objection.
All right. So are there any witnesses that anyone wishes to present? State?
So the state doesn't have any witnesses. The main thing that we wanted the court to be aware of was the statement from the complainant, which the court has already noted that they read.
Yes. Defense, any witnesses?
Your Honor, other than my plea and our arguments to you before considering sentencing in this matter, I will be speaking and Ms. Segundo may say a couple of words, and Ms. Segundo's parents are present in support of her today. They can stand with Mr. Standing here in support of her today.
All right. Thank you.
They will not be speaking.
All right. So before I begin with your presentation, with regards to the case to be taken in consideration, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
Gracie Segundo.
All right. And with regards to County Court Cause number 6933701, the state is taking that case into consideration, but to that case, how do you plead?
No contest, sorry. I'm just so nervous.
That's okay. So in order for me to take that into consideration, she will have to accept full responsibility for it. So a no contest plea, I can't accept that because I don't have any police reports in regards to that. So she will have to enter a plea of guilty to it and accept responsibility for it. And then the state will tender dismissal to the court and the court will sign that. I don't know if you want to discuss that with her.
I will go ahead and proceed with a guilty plea, Your Honor.
All right. So the County Court Cause number 6933701, how do you plead to that?
Guilty.
All right. And state, do you have the dismissal
Yes,
for the
Judge.
court in that cause number? All right. So the court then will hear argument. State, you're opposed to deferred adjudication?
Yes, Your Honor. The reason why the state is opposed is because of the nature of the offense, the actual underlying facts. There was an assault that occurred where the resulting assault it created a lot of issues for the complainant. She was severely injured. Her life was severely impacted from that day forward, and she still feels the impact to this day. It's something that was senseless and didn't need to happen in the first place. So that's why the state is opposing deferred and is asking for probation.
Defense?
Your Honor, we're here because one incident can't define a person for the rest of their life. And this is very serious, and no doubt we take that very seriously. This is a felony charge. It's a felony charge that carries a very significant penalty. But Ms. Segundo, I think, has demonstrated a respect not only to others, but to life and to animals, and in her work and her career in taking care of pets. Rarely do I have an opportunity to where a client will provide 32 letters of reference about how wonderful she is with caring for others. And that is the life that she defines herself with. We just feel like this should not define her as a felon for the rest of her life when she has 4 children as a single mother. We know that life is difficult and it's very, very, very hard. And she's having to raise 4 children on her own, ages 15, 14, 12, and 10. As a single mother, she has to be involved in their school activities and support their activities with FAA. And a felon cannot be associated with children and be around them in school activities. This would drastically impair her ability to be a mother to her children. And so she's really fighting to be able to continue to provide the love and the support of 4 children that need their mother so that they can become better than her and have a future. She lives in Houston. She leases a home. She's lived in that home for 3 years. She has good family support. As I've said, her mother and father are present. She has a high school diploma. She has been employed during this whole time. This case is 2 years old. 2 years this week, this happened. And it's been 2 years that she has been experiencing this, and she has complied with everything this court has asked. She's appeared in court. She's traveled from Houston to San Antonio. She has fully cooperated. She has weighed all of her decisions and sought not to seek a trial, but to put the decision on deciding her future on you. And she made that decision because she felt that was in her best interest. She does receive some child support. She is willing to do everything and anything that it takes to give her this opportunity. I explained to her that deferred adjudication is a double-edged sword. You may think that you're not going to be subject to a conviction, but in actuality, you are subject to all the conditions and behavior for 7 years. We're asking you, Judge, to give her that chance, to give her the opportunity to prove to you that this one incident does not define her life or who she is or how she is as a mother or how she works. This case was very regrettable, and it should have been a day of celebration. It was after a football game, and she was acting in defense of another. She doesn't know the victim in this case. She doesn't know the judge. She never knew who she was. And I sincerely believe that just because she's a judge doesn't mean that this case should be treated any different than any other case of any other person who comes to this court and gets justice, because she should get an opportunity to do it. She's willing to do the urine analysis. She's willing to state no contact, and she's had no issues in the last 2 years with the defendant, the complainants in this case. She's willing to take anger management classes. She's willing to do community service. She's willing to do what it takes to give her the chance. And she has proven, other than this one incident that happened in a flash, wasn't premeditated, it wasn't thought of, it was just something in a reaction and defense of someone that she was with. And for that reason, we think that she should be given an opportunity to earn the right to be able not to be a convicted felon. The amount of restitution in this case, I think we've agreed to, that was presented before the court, was $2,416.29. We fully agreed to repay that. We will work hard every day to pay that back. But in this working community and in Houston and San Antonio, mothers every day have challenges. And we regret that this happened. And I know that she sincerely has nothing personal against Ms. Martinez or her husband. She wants to do what's right, but she also wants a chance, Judge. And I'm asking you with all the fiber of my body to give her that chance. And I will make sure and work with her that she will comply with every condition, so she will never be back here before you regarding any violation or any condition of this case. You want to say something?
No, I'm nervous.
All right. Well, just so you know, in this court, I see everybody as a human being. I don't see them as their titles. So for me, defendants are not defendants. They're human beings who are accused of a crime. The fact that Rebecca Martinez is a judge, that doesn't mean that I'm putting weight on the fact that she's a judge. If she were the president of the United States and she were here as a complainant, I wouldn't put weight on the fact that she's the president of the United States. I'm just dealing with the facts here. And my job is to look at everything objectively and not outside noise, not what people's occupations are. You understand? So I always reread everything and reread police reports and the PSI report, and I've read the letters. I do not understand how the fact that an elevator has a limited capacity, how we go from people saying the elevator is full, you cannot be in an elevator, to it's a brawl. So explain that to me.
I mean, it just, I don't know, I couldn't tell you.
I mean, there has to be some sort of thought process. For example, if there's an elevator, I think everybody knows there's a weight capacity on the elevator.
Mhm.
Me personally, when I see there are too many people on the elevator, I don't get on. But obviously what we are here now for is there's an elevator. According to everything that I've read, the elevator was at capacity. And there were already some people on there. I don't understand how an elevator is at capacity. People need to get off or more people can't come on, how that ends up in a fight.
Yeah, I couldn't tell you how it started. I just, somebody in my party was getting into it and somebody hit me and I just reacted. And unfortunately, I feel bad and should never have done that. Shouldn't have got to that. It just happened really quick.
I know things happen quickly, but the police report I'm reading, it doesn't say that somebody in your party got in an altercation and you got hit, and so therefore you got into a fight. What your counsel is telling me is that somebody in your party, I guess, was in a fight, and then you decided to get involved in that fight.
I went to go and try and pull my friend away, and then like I don't know, it was just a bunch of people, and somebody hit me, and I just reacted.
Your Honor, if I could clarify, I think the facts is this is a COVID era situation in the elevator. These elevators can accommodate 18, 20, 22 people, and they were limiting it to
10 minutes into this hearing, and the tension cuts through every word. What began as a packed post-game elevator turned violent, and today it decides a woman's future. The state calls it senseless violence, claiming the complainant's life was changed forever. The defense insists this was a moment of chaos, not cruelty. And when the judge leans forward and asks, "How does a full elevator turn into a brawl?" you can feel the whole courtroom hold its breath. Behind the calm tones and polite words, lives are hanging in the balance.
to 7. And as people went into the elevator, the policy and procedures of the elevator operator of not allowing people to come in once they met capacity. They were in the elevator. They were asked that there was too many in the elevator. And then people had to decide who's getting off. And they asked who she was with, another man and another person, to get off the elevator. That person said, "I want to talk to your supervisor." That individual entered into an altercation with the victim's husband that spilled out of the elevator onto the floor. She came in assistance to that man, and that's when she was hit, and that's when she struck the victim. That stated in one of the reports here that was provided to you in the PSI. And she did not go in there to fight. She didn't go in there to look for someone to fight. She was trying to get someone off of her friend. And in the process of that was struck, and she injured Ms. Martinez. And so it's regrettable, Judge. There's no doubt about that. And this incident happened in a matter of seconds. And that's why we're here 2 years later doing that. And in addition to that, Judge, there is a civil suit in this case where the parties in this case are seeking $1 million in damages against my client. And so this case will not end today. It will continue in a civil matter with a lower burden of proof, where she will have to defend herself in a civil cause of action for money damages.
And Judge, just to clarify from the state's end, I would disagree with the characterization of how the incident started. The party was already on the elevator. The complainant's party was already on the elevator. They were asked to not enter the elevator. They weren't kicked off the elevator. They were asked not to enter.
They were in the elevator.
And that's what started it.
And I also have a copy of the lawsuit that was filed this week before the sentencing, where they're seeking $1 million damages in civil lawsuit right here. You want to see it, Judge? It's public record.
I would object just because relevance.
So lawsuits and filed in the city court. That's a copy from the courthouse.
All right, unless there are some facts that are listed in the
It leaves the
lawsuit.
whole case, Your Honor. Exactly what you're talking about is pled in the civil suit.
I mean, if that document has facts that somebody has, well, alleged facts that somebody has presented, that's a different rendition from what's in here, then the court will,
It does not, Judge.
all right, so,
Just to let you know, there is a civil suit.
all right, then the objection will be sustained. All right. Anything else from either side?
No, Your Honor.
No, no.
All right. I've read your letters that were presented, and it appears that, other than this one incident, you're a great person. But sometimes sentencing, well, not sometimes, always sentencing has to do with punishment, rehabilitation, and basically whether or not someone should go to prison or not go to prison. These are all things I have to think about. You understand? And so I have to weigh certain things. And the things that I'm weighing are the fact that there were people in the elevator and you were asked not to get on the elevator. Is that correct or is that not correct?
You were on the elevator.
Your Honor, the elevator's doors open. They entered into the elevator and they were asked, there were too many in the elevator, and the elevator operator asked people to voluntarily get off.
All right, so there were already people on the elevator. Then you got on the elevator and you were asked to get out?
Us just walked in at once.
All
And
right,
then
and then you were asked to leave.
they said we need people to get on.
All right, so why didn't you just get off the elevator? That's what I don't understand.
True. You didn't decide that.
Yeah.
She didn't decide that. It was a person that she was with, Your Honor, who is a defendant in the case that's in another court.
So my question is though, if there are too many people on the elevator, and let's say you get on the elevator, it's a group of you, the elevator is already filled. I'm assuming, and correct me if I'm wrong, people were on the elevator, they had not met maybe their 7-person capacity. And then you and your group come on, and because of the number in your group, they've exceeded their 7-person capacity. And then they're saying, you all need to get off the elevator and wait. Why not just get off the elevator? That's what I don't understand. Even if you're with somebody in your party who says, I'm not getting off the elevator, why didn't you just get off and I'll wait for the next elevator? I'll take the stairs. I don't understand.
We had already gotten off 2 floor, so we said like we've been waiting, but we didn't want to be the ones to get out.
And was alcohol involved, or people just don't want to take
It
the
was after a
stairs?
football game, Judge.
Estate, does anybody want to? I know the complainants are here. Do they want to
No,
say anything to the court?
no, Your Honor.
Okay,
Oh, Your Honor, may I have one moment?
yes. And then after this, we're going to take up Pete Diaz, Emmanuel Castro, Michael Martinez, Larry Berry, and Michael Moore.
Your Honor, I'm going to call case Martinez.
Okay,
Your Honor, he's not occurred outside the elevator as a result of defending another person. She doesn't deny that she struck Ms. Martinez, but this was a situation where she was struck as well. And we believe that this one incident that wasn't premeditated, it wasn't started or caused by her. You know, it reminds me of a penalty, and another individual comes in their aid, and then another flag comes up for a penalty, and they both get penalties. And most cases in sports, that's offsetting. And I think in this case, at looking at the situation, looking at history since that day, that I think it would be fair to give this single mother a chance to continue her life and being a mother and working at her employment. So not to have this crash down on her with her children, with her workplace. We can't promise that she will keep her job upon this conviction. We cannot promise that she can be able to parent her children and be the primary caretaker of her children as a result of this conviction. But we can promise that if she is given a chance, she will do everything in her power to remain on probation for 7 years, to do what's right, so not to be considered a felon in a situation that she wished never had happened. There's no ill will here. There is no desire on her part to do anything but to move on with her life and pay what's owed, the $2,500, and do what it takes to win your trust. So we're asking, Judge, that deferred adjudication be given to this woman so that she can continue to do her life and do good for her children and her work and her community.
State, any final arguments?
Your Honor, the concern from the state here is, again, the facts of the case. It's that, yes, she wasn't the instigator, but she chose to take it to this level. It was her choice to take this out on the complainant. It was her choice to get involved against the complainant and to not show restraint. It's the issue that this all started over something very trivial, that if just a little bit of patience, this would have all passed over. That moment that she decided to act how she did has affected the complainant from that day until today. And it's going to affect her past this. That's why the state is asking for probation on this case and for you to not grant her deferred adjudication.
All right, so what is the amount of restitution and who is the restitution to?
It's to Rebecca Martinez and
$2,416.29.
Wait, 2,400?
$16.29.
And also in the plea bargain agreement, it says restitution to,
Jeanette Rojas.
yes.
Your Honor, so we haven't gotten any medical or billing from there. We would ask restitution to be determined on that amount.
All right, so with regards to the restitution to Jeanette Riojas, if there's a restitution amount that's submitted to the court and you all have objections to it, we can have a restitution hearing.
Thank you.
And I'll just write in that there's to be a restitution hearing as it relates to Jeanette Riojas. And I'm assuming she's going to want to transfer to Houston.
Yes, Your Honor.
And what,
It's in Harris County.
all right, Ms. Segunda, I've listened to all arguments. I want you to know I paid very close attention to the arguments that were presented, to the witnesses, and to all of the documents that the court reviewed. I realize that sometimes when things happen, it's just a Snapchat or somebody's life, right? It doesn't mean that the person is a horrible person. And I'm sure if people could go back and change things, sometimes people are serious when they say, if I could go back and change things, I would. Maybe I never would have went to the game. I would have just let the elevator went. I would have taken the stairs. I understand that. But we can't turn back the hands of time, right? And the problem in this case, and one of the things that I'm looking at is the fact that the complainant has serious injuries. And it has nothing, my consideration on whether they're a judge or not, that's not playing any factor in my decision. If she did not have that occupation, let's just say she worked at the HEB, for example, then based upon her injuries, she wouldn't be able to work at the HEB. She wouldn't be able to stock. She wouldn't be able to stand and be a cashier. I don't know what they would have her doing at the HEB. You understand? So her injuries are very serious injuries. And I've read the report that was given to me about her injuries, and I've read the PSI report, and I've read the police reports again in this case, because I always like to review things. So I understand that you're very sorry for what happened, but sometimes, yeah, it's great that you're sorry. It's great that you've internalized things, but there is still some punishment associated with it. And I understand that sometimes when people have felony convictions, they say, well, now I can't do this, I can't do that, I can't do this. But then when you look at the complainant has some lifelong issues. And that's the report that I was given and that your attorney has read. The injuries that she suffered are not going away. And from the report I read, it sounds like they're never going away. She's always going to have those injuries. And I think you know that when people have broken bones, there's a change in the weather, their bones ache. I have it with my fingers because at one point in time, all my fingers were broken on my left hand. So I know when the weather is changing, it gets a little bit painful, not unbearably painful, but it does. So those are a whole host of things that happens when somebody suffers the injuries that she suffered. I understand, as I said, that you're sympathetic, and I believe that you're sympathetic, and if you could do things over, you would. But I am where I am right now, okay? All right, this is what the court is going to do. Court will find you guilty, sentence you to 7 years in the prison, suspended and probated for 5 years. There's a $500 fine that will be probated.
The courtroom slows as witness David Martinez takes the stand. His words sketch the chaos. A crowded elevator, raised voices, children crying, then a fight spilling out into the hallway. The defense anchors their case on defense of others, arguing Ms. Sigona stepped in only to protect a friend. But here's the legal tension. Even a justified act must be reasonable. The state fires back. Choice, not chaos, defined this moment. When restraint could have been safety, she chose confrontation. In these 60 seconds of testimony, the legal line between protection and provocation blurs.
There's a transfer to Houston, Texas, Harris County. Taking consideration County Court Cause number 693701. There's to be restitution of $2,416.29 to Rebecca Martinez. There's to be no contact with Rebecca Martinez or Jeanette Riojas. Proof of employment within 45 days. There's to be no employment as a home health care provider with minors. 100 hours of community service restitution. That'll be waived once you complete parenting classes. There's to be regular reporting by Zoom or in person, regular UAs, and restitution hearing as it relates to Jeanette Riojas. I don't see this as an anger management situation. I see this as an aberration. I think she doesn't need anger management classes. So is there anyone going to object to me not giving her anger management classes?
The state won't object, Judge.
All right. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful? All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yeah.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
No.
All right, we can go off the record. So what I've learned in my time on the planet, it's just best when somebody says, oh, you can't do that, and you want to argue about it, pick another day to argue about it. You understand? All right, good luck to you.
Thank you.
Pete Diaz?
Your Honor, may I quickly approach?
Yes.
I don't remember what order you filled up. I have Larry, right, and I think you have one on each set.
He's after this. So let me take up Pete Diaz, then I'll get to you. Pete Diaz?
Yes, ma'am.
All right, thank you. Who's the attorney for Pete Diaz?
I don't see him.
All right. Mr. Diaz, if you'll have a seat. Emmanuel Castro. Who's the attorney for Emmanuel Castro? This is Criminal Trial Division.
Morning, Judge.
Good morning. Court is calling 2017 CR 4326B, State of Texas versus Emmanuel Castro. Can I have parties announced for the record for the state?
Laura Metzel for the state.
Defense?
Stephen Hartwich for Emmanuel Castro.
Are you Mr. Castro?
Yes, ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
No.
Are you the same Emmanuel Castro who was placed on deferred adjudication in 2017 CR 4326B for the offense of possession of marijuana, 4 ounces to 5 pounds on September 6, 2017 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 5. In Bear County, Texas, the defendant Emmanuel Castro did then and there fail to report to the supervision officer as directed for the months of June, July, August, September, October, November, and December 2018 in violation of condition number 5.
Just one moment. I don't have that motion. Is that a supplemental?
No, it's on the, oh, sorry, it is on the supplemental, Judge. I apologize.
All right. Mr. Castro, I'm going to show you what's entitled State's Motion to Supplement Pending Motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney as well and understand it?
Yes, ma'am.
All right, then to violation of condition number 5, how do you plead, true or not true? State?
And then on violated condition number 5, the second one, Your Honor, in Bear County, Texas, the defendant Emmanuel Castro did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, and December of 2019 in violation of condition number 5.
How do you plead to that, true or not true? I'm sorry, you need to.
And we'll waive the remaining violations, Your Honor.
All right, any objection?
No, Your Honor.
Did you understand by pleading true to violations 5 and 5, the court could find it true, grant the motion, find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine? Knowing that, do you still wish to plead true to 5 and 5? Court
Yes, ma'am. Sorry.
will find 5 and 5 true. Is there a proposed agreement?
Yes, Your Honor, there is. For revocation and adjudication and to proceed forward on sentencing under 1244A for 45 days in the Bear County Jail.
We're just gonna recommend 9 days.
He says on his credit for 45 days. Give me 1 second, Your Honor, to make sure it's not my offer.
Sure. All right, so what are you?
Because his agreement on here says for 45 days, and so I'll just need to verify with him that he changed it to 9 days. Yeah, his offer is for 45 days on here, so I'll need to verify with Daniel, because he didn't make any changes on here to verify that he agreed for the JSOC.
All right, so here's the question. Why should I give him 45 days or even 90 days under 1244? Has he done anything?
Judge, as a condition of his bond, asked him to take sober
Support meetings?
support meetings. He did attend that. Would you like to approach her?
Yes. Any objections to the court?
No, Your Honor. Also, Daniel Escobar from the state of Texas.
So what is the proposed agreement?
It was for 9 days in the Bear County Jail under 1244, Judge.
9?
9. And probation was recommending judgment unsatisfied. So
All right. And how much time does he have in?
I think 9 days.
9 days, Judge.
All right, I don't think 9 days is appropriate. So, I mean, you're gonna have to go to the Bear County Jail. You understand?
Yes, ma'am.
All right. So what I'll do is I'll grant the motion, find him guilty and sentence him under 1244. And I'll sentence him to 30 days in the Bear County Jail. And I'll give him credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? All right, you have a limited right to appeal. That's as it relates to the allegations in the motion, not the fact that you were on probation. Do you understand?
That's fine.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. So here you go.
Sorry.
No problem. Oh, you know what? Can I see that back for a moment? I think I took my docket sheet there. Larry Berry.
This is where humanity cracks through the legal script. The defendant, shaken, regretful, says it happened too fast. The judge listens but presses on the same question. Why not just get off the elevator? That's the heartbeat of this entire case. One decision, stay or step away, spiraled into an injury that changed another woman's life. And yet, sitting here, it's impossible not to feel the weight of both sides. A single mother of 4 terrified of losing everything, and a victim still fighting pain 2 years later. The law demands judgment. Compassion demands perspective.
Morning, Judge.
Good morning. What is happening with this case?
Judge, the hangup is this, we were set for a PSI today for sentencing.
Mhm.
I've read the pre-sentence investigation report. Among other things, it's recommending that Mr. Berry go to residential treatment, a dual diagnosis.
All right, so has the PSI report been done?
Yes, I have it in front of me. The problem is, Judge, is that earlier this week on Monday, Mr. Berry, there's no bus service to wherever he had to go to have this mental health evaluation that you ordered be done. So he walked 2.5 hours, got there at 8 a.m, was told his appointment wasn't until 12, and that the evaluator would be there the rest of the day and they would call him and tell him when to come back. He said they didn't call. The next available date, according to probation, is November the 13th, too.
Probation?
Yes, Your Honor, we set that appointment.
All right, for Mr. Berry, what is happening with him?
Just as counsel was stating, Judge, we've done the PSI, we've done the TAP. The TAP recommended further investigation or further evaluations with Center for Healthcare Services. That appointment was supposed to be on Monday. There was a failure they reported a failure to report. I understand what Mr. Berry may have said. So he was not evaluated on Monday. I did reach out to them to see when the next available possible date would be, and that would be on November 14th at 2 p.m. I did stress to counsel that Mr. Berry needs to make sure that he has, arrangements, make sure he's there on time, and he does not miss this.
Do you understand?
Yes, ma'am.
If you miss that appointment, what's going to end up happening is we're going forward with this sentencing. Do you understand?
Yes, ma'am.
And a warrant may be issued for your arrest, and then they will have the appointment for you if needed at the Bexar County Jail. Do you understand?
Yes, ma'am.
All right, Ms. Ferguson, can you recall this back for November 16th?
Yes, ma'am, I already have it.
All right,
May I just check the calendar, Judge, to make sure I'm all right.
all right, they'll give you your reset form. Michael Mora. Counsel, on this one, the state's supposed to present to the court the criminal history.
And I did inform her of that.
All right. So if you all will step back for 2 minutes, and let me review that. And then Ms. Ferguson, when do you want to recall Mr. Stryjak since his counsel is in trial and the 290th?
It'll take about 3 days.
Okay, so,
You can do it next Thursday. The 26th.
all right.
May I put you on there?
Yes. Stryker. Yes, he did. He did announce.
Somebody just reset it or?
Yes, just reset it. Zachary Guerrero. And counsel, you're on this side. Free Nell, could I have party for the defense?
Tim Molina for Mr. Guerrero.
All right, is your client ready to proceed?
Yes.
All right. Mr. Guerrero, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Your Honor, we were approaching about an announcement regarding the NTR.
Okay, that's okay. So what is happening?
As the court can tell, there's a new number 1 violation
Mhm.
allegation of aggravated robbery that was, I guess, the offense date is the end of August.
Mhm.
The discovery is not complete. I have received what they have, but there are other items that we do need to review. And given the serious nature of his underlying offense that he's on probation for, and the fact that it's deferred, and then the allegation of the first degree in the new offense, I'm asking for a brief reset. The state has indicated they are going to reach out to SAP to have the rest of the discovery completed. We were going to ask for a 2 to 3 week reset. I would only point out that I'm pro tem on a capital that's starting November 6th. It'll be over that week. So I was going to see if we could move it to November the 13th that week to come in and hopefully try to work something out.
All right, Ms. Ferguson. On this case, can you set it for a contested? And if it ends up being a contested, it's contested. If it doesn't, then it doesn't. And can you recall it in December?
And I don't know, his aggravated robbery case has a setting on my calendar, I think next week.
We'll move
as a
both of
night mag,
those.
But I don't know if the court does.
We don't do night mags unless defense counsel requests it.
Okay,
All right, we're going to come back on December 7th for a contested.
okay, thank you.
You're welcome. And counsel, if you want it sooner than that, then he can be brought back sooner.
Thank you.
You're welcome. Christian Smith. All right, where are we on the PTD?
Good morning, Your Honor. Mr. Smith had a little family issue going on, so he hasn't completed the classes he needs to get a dismissal for PDD. So we're just gonna ask for one more reset so he can be able to complete his classes.
All right, Ms. Ferguson, can I have a reset for PTD on Mr. Smith?
You can come back on November 14th.
All right, we're going to set you for
Judge,
November.
I
Yes.
will be out of state on November 14th, and I don't wanna,
All right, well,
that whole week I'm out of state.
Okay, then he can come back on the 9th.
all right, November 9th.
November 9th. Sounds good.
All right, thank you.
Thank you. Have a seat.
Judge Steve on page 8.
Thank you. Pete GS. And then Ms. Kramer. Your case will be next. Good morning. All right, are you all ready to proceed?
Yes,
All right, I need a trial court certification. I don't have one.
but we keep going to be continued.
Not unless I say so.
I mean, that's. If the court decide not to do the agreement.
Mhm.
Then I can do one then, but I
All
can do
right.
it now. Judge.
All right, thank you. If you could, please. Oh, it's on the wall, Mr. Cox.
By now, the evidence has spoken. The defense pleads for mercy. 32 letters describing kindness, motherhood, and work ethic. The state, steady but unflinching, calls it a matter of accountability. The judge's voice softens but never sways. She weighs punishment, rehabilitation, and public safety, the holy trinity of sentencing. Every word circles back to that elevator moment, because in law, motive matters, but consequence never disappears. And the next words will decide whether this mother walks out on probation or walks away in handcuffs.
Yeah, 2125D.
Thank you. All right, court is calling 2021 CR 2125D, State of Texas versus Pete Diaz. Can I have the parties announced for the record for the state
Chandler Bowen for the state of Texas.
defense?
Cornelius Cox for the defendant.
And are you Mr. Diaz?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Pete Diaz who was placed on deferred adjudication in 2021 CR 2125D for the offense of theft $30,000 to $150,000 on September 29, 2021 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
We're proceeding on a violated condition 8B. On or about the 31st day of July 2023 in Bexar County, Texas, the defendant Pete Diaz did then and there fail to report to the supervision officer on the next working day after being released from jail for a new arrest in violation of condition 8B.
How do you plead to that? True or not true?
True.
We'll waive the remaining allegations in the motion, Your Honor.
Okay.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
No.
Knowing that, do you still wish to plead true to violation of condition number 8B?
Yes, ma'am.
Court will find violation of condition 8B true. Is there a proposed agreement?
There is an agreement, Your Honor, subject to the court's approval. That is to deny the MTR, continue him on supervision with amended conditions, specifically to include the batter's intervention and prevention program, to continue his compliance with the San Antonio Fatherhood Program, to impose a no contact order with Jessica Contreras, to have the defendant enroll in intensive outpatient treatment, weekly UAs until he's testing clean, and then back to regularly or randomly scheduled UAs.
That's great.
All right, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Yes.
All right, so what drug would you be positive for? That they're saying they're trying to wait till it gets out of your system?
They say it was meth and opioids.
Mhm.
I haven't used any, at that time, everybody at the work was getting sick and I worked with a bunch of seniors. They had gave me different kinds of meds. I took it, but I understand that I shouldn't be taking anything, but I took they're all retired nurses, surgeon nurses, and
So you're just saying they just gave you free medication?
they saw me sick. I'm the maintenance man for them, and they're trying to, I guess, make me feel better. I should have just gone to the doctor and took some medication from there. I was taking all kinds of, my boss came out positive for COVID.
And who is Jessica Contreras?
She's my baby mother.
You mean the mother of your child?
Yes, two. Two girls. We're no longer together. She's moved toward Tyler.
So she's in a different city?
Yes, ma'am.
And what is happening with this new number one?
It's gonna be rejected, Your Honor, as part of this agreement.
All right, court will deny the motion. Alter and amend conditions. To include the BIPP course. Parenting classes. Is that covered on the San Antonio Fatherhood Program?
I believe it's a similar program, Your Honor.
All right, probation, if the San Antonio Fatherhood Program is similar to the parenting classes, then the court will accept that. The BIPP course. No contact with Jessica Contreras. So for any visitation, you'll have to do that through a third party. Do you understand?
Yes, ma'am.
Yes. So who is the probation officer for Mr. Diaz?
Your Honor, so happy then.
All right, if you'll come forward, please. All right, so Ms. Martinez, with regards to Mr. Diaz, they're recommending the BIPP course, San Antonio Fatherhood Program, no contact with Jessica Contreras, and intensive outpatient treatment with weekly UAs. Is there anything else you think he may need, or have there been any other issues with him?
No, ma'am, that's fine.
Okay. All right, and so what we'll do is we'll do the intensive. I'm really torn on asking for intensive outpatient treatment because he's saying that the reason he tested positive is for medication that he was given where he works.
Yes, that's what he told me.
So have there been any other positives with him?
No, Your Honor, but we did get it confirmed and with the lab, and it did test positive for methamphetamine.
Well, is that from a medication?
It didn't say, it just said it was positive for meth.
All right, this is what I'm gonna do. Do you have a drug problem, Mr. Diaz? We're gonna do UAs. And we're gonna do weekly UAs. Or either you can do the patch. And then once he tests negative, we're gonna start with random UAs. And if there's a positive UA, then we'll see where we are. So there will be weekly UAs until a negative test is presented. And once it's negative, and can you test for levels to make sure things are not going up?
I believe it's only for marijuana. We test the levels.
Well, here's the thing. This meth should not be in your system after this week. Do you understand?
Yes, ma'am.
All right, so we'll do weekly UAs. until he's negative. So I'm gonna want him tested every week. And then thereafter, it will be random UAs.
Can we do the IVR for the random?
Yes. So it'll be the hotline for the random UAs. Do you understand? Is there anything else you need from the court to be successful?
No, ma'am.
Is there anything else he needs?
No, ma'am.
All right, good luck to you.
Thank you.
You're welcome. Yes,
Can I just verify, you said we were not gonna go with intensive outpatient treatment?
no.
Okay.
There you go. Thank you. All right, and then we're ready on Michael Mora. And after Michael, yes, sure. After Michael Mora, it's gonna be Leonard Johnson, Michael Martinez, Christian Smith, and Darianne De La Rosa. Thanks for your patience.
Thank you, Judge.
All right, court is calling 2023 CR 4008, State of Texas versus Michael Joseph Moore. Can I have parties announced for the record for the state?
Laura Metzel for the state.
Suzanne Kramer for Mr. Moore.
And are you Michael Joseph Moore?
Yes, Your Honor.
All right, you entered a plea in this case on October 5th to count 1 of no contest. The state waived count 2. The court found that there was sufficient evidence to find you guilty. The state was silent on your application for community supervision. Because there is such a length of time for PSIs, the court just ordered your criminal history. And the court will use that as a basis on whether or not to grant your application. The state is silent. Anything you wish to say on behalf of your client?
Yes, Judge, just a few things. While on bond,
The judgment lands. Guilty, but not forgotten. 7 years in prison, suspended and probated for 5. A $500 fine, 100 hours of community service, and $2,416.29 in restitution. No contact with the victims, no work with minors, regular reporting, and UAs. It's not freedom, it's structure. The court sees it as an aberration, not a pattern. This is how justice threads the needle. Firm on accountability, flexible on redemption. A suspended sentence isn't mercy. It's a test, one she must pass every single day for the next 5 years.
I don't really remember what got us in front of you, but we were in front of you on something. And you had just given a recommendation to Mr. Mora that he might, while on bond, seek some treatment for himself, which he did do. He started going to Lifetime and got with a counselor named Peggy McIntyre.
Mhm.
And in fact, he was going to go into the inpatient section of Lifetime, but he got arrested. And I'll just remind the judge, it wasn't for anything other than Mark Garcia with A Action or Cowboy. I can't remember which particular bond company were
Yes.
with Cowboy. Although I had been here earlier that morning, he came in knowing I was here after I left and asked Judge Harrell to increase the bond because Mr. Moore apparently missed a check-in. So that's what got him back in custody and unable to participate in the inpatient program at Lifetime. But I also wanted him to because it sounds much better coming from him when he talks about how he was so upset about going to jail because he really wanted to get this help. He had no court order requiring to do it. He did it all on his own. If you would like to hear from Mr. Moore, he can speak with you.
Sure, if you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record, please.
Michael Mora.
All right.
And Michael, I had talked to you about, you will be allowed to speak with the judge about your desires to seek help and why you went and got it, even though you weren't court ordered to do so. Did you let her know a little bit about that?
I just my counselor has just told me how would you feel getting impatient, and I told her yes, I'll do it. You know, I do it just, you know what I mean, just to get the help. And after I got enrolled, my drug test started coming out clean. I started coming out, you know what I mean? Negative on my UA. So just, I felt like it was a good help and it was helping me.
So, I mean, I'm not sure that he's ever really had any kind of help before. I'm not sure that he's ever before. He's getting a little bit older now, had the desire to seek help, but he did it on his own. You did not court order him. I do not believe to do it. It's a condition of bond. And I think that speaks very well for his incentive to do well on this probation if you so grant it.
Yeah, I don't have. All right, thank you. Just 1 second. I'm being told that you pled to 2 cases and I only have 1.
Oh, you know what? It was like 4,008 and. Yeah.
Yeah, 4,008 and 3876, Your Honor.
Okay. All right, so they're gonna give that file to me.
And then comes silence. The courtroom feels lighter, but no one breathes easy. The judge reminds everyone, titles mean nothing here. Not even a judge-turned-victim changes how justice must weigh truth. She speaks like someone who's seen this too many times. Small conflicts, big consequences. If I could go back, the defendant says, I'd have taken the stairs. That single line captures everything. How seconds of anger can rewrite years of life. Justice, it turns out, isn't about perfection. It's about what we learn after we fall.
All right. So we're back on the record and we're also on the record in 2023 CR 3876. Is that correct from both
Yes, ma'am.
sides? All right, and that's an evading case. All right, State, I know you're silent, but are there any fact issues you wish to bring to the court attention?
No, Your Honor.
All right, Mr. Mora, people say all the time that probation in this court is hard. And I guess it is, but I'm trying to do things to help people rehabilitate themselves so they will not be back in front of me again or in front of another court again. So you have a choice. I can grant your application for probation, or either I can sentence you to 5 years in prison on each of the cases. Which would you prefer?
Probation.
Okay. All right, this is what the court is going to do in each case, and the court will note the evading arrest and detention was evading an arrest on a bicycle.
Yes.
All right. So just 1 moment. Just 1 moment. Just a correction for the record. The case involving the drug case was on a bicycle. The other evading was in a vehicle. All right, in each cause number, the court will sentence you to 5 years in the prison, suspended and probated for 7 years. Each case will run concurrently. And it will also run concurrent with 701883. Take in consideration 2023 CR 4009 and 689573. You're to forfeit any weapons. All right, do you have any children? You need to answer.
No, no, Your Honor.
All right. You're going to be inpatient treatment with lifetime recovery. And that's to be transferred by lifetime recovery. So once they pick you up, you'll be allowed to go. We're going to start off with GPS. And that'll be GPS for, let's do 4 months.
Will that be full or partial, Judge?
We're going to start off with full because he should be in his recovery at lifetime. And if
Okay.
lifetime feels that it's time for him to start working, they can approach the court.
Thank you, Judge.
And I'll ask that the fees are waived or deferred. There is to be the UA hotline and probation. I'm sure lifetime recovery is doing their drug testing as well. If you want to accept their drug testing for that, you can. Proof of employment within 90 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. And field visits one time per month until further notice. And probation, with regards to field visits, if you all know that he's at lifetime recovery, you can just call or either accept the fact that he's at lifetime recovery.
Final ruling,
Are y'all
State
prepared to proceed or
versus
no?
We are, Your Honor. The
Sigona.
motion to
Guilty
revoke,
with a
him
7-year
agree-
sentence suspended
Okay,
and
Mr.
probated for
DeLeon, I
5.
need a
Restitution
Stockport
paid,
certification.
contact banned, community service required.
I'll get
The
that for a
judge calls it an aberration,
Okay.
a flash of human error that can't be undone, but can still be redeemed. For the victim, it's closure. For the defendant, it's correction. And for us, it's a warning. Next time tempers rise in a crowded space, remember this courtroom. Remember how one push became a punishment. If you found this case as gripping as we did, hit like, share your
Do you
thoughts
have
in
a
the comments,
highlighter?
and subscribe for more real courtroom drama. Right here, every week.